Introduction. S.V. Makwanyane and another was a landmark 1995 judgment of the Constitutional Court of South Africa. It established that capital punishment was inconsistent with the commitment to human rights expressed in the interim constitution. 2. Facts and legal question. 2 accused in this matter were convicted in the Witwatersrand Local Division of the Supreme Court on 4 counts of murder, 1 count of attempted murder and 1 count of robbery with aggravating circumstances. They were sentenced to death on each of the counts of murder and to long terms of imprisonment on the other counts. They appealed to the Appellate Division of the Supreme Court against the convictions and sentences. The Appellate Division dismissed the appeals against the convictions and came to the conclusion that the circumstances of the murders were such that the accused should receive the heaviest sentence permissible according to law. The core issue was what bearing the interim constitution had on the death penalty. Did the death penalty violate Sections 9, 10 and 11(2), which guaranteed every individual the right to life, the right to dignity and the right to be free from torture and cruel punishment? 3. Judgment. In its judgment, the court unanimously found that the death penalty was indeed unconstitutional. The court held further that the rights to life and dignity were the most important of all human rights and the source of all the other personal rights detailed in Chapter 3 of the interim constitution. Having committed to a society premised on the recognition and realization of human rights, the state was required to value these 2 rights above all others, and to demonstrate that valuation in everything it did, including the punishment of criminals. This would not be achieved by depersonalizing and executing murderers, even as a deterrent to others. Quite apart from the fact that vengeance or payback had not the same constitutional heft as the right to life and the right to dignity, the court was not satisfied that it had been shown that capital punishment would be more effective as a deterrent than a life sentence. Chaskalson P., writing for the majority, concluded that the death sentence destroys life, which is protected without reservation under Section 9 of our Constitution. It annihilates human dignity, which is protected under Section 10. Elements of arbitrariness are present in its enforcement, and it is irremediable. I am satisfied that in the context of our Constitution the death penalty is indeed a cruel, inhuman and degrading punishment. In the balancing process, deterrence, prevention and retribution must be weighed against the alternative punishments available to the state, and the factors which taken together make capital punishment cruel, inhuman and degrading: the destruction of life, the annihilation of dignity, the elements of arbitrariness, inequality and the possibility of error in the enforcement of the penalty. 4. Ubuntu. Since S.V. Makwanyane, Ubuntu has become an integral part of the constitutional values and principles that inform interpretation of the Bill of Rights and other areas of law. In particular, a restorative justice theme has become evident in the jurisprudence that encompasses customary law, eviction, defamation, and criminal law matters. This contribution explores the scope and content of Ubuntu, as pronounced on by the judiciary in various cases, and demonstrates that its fundamental elements of respect, communalism, conciliation, and inclusiveness enhance the constitutional interpretation landscape. 2 major epochs are highlighted in the development of Ubuntu, marked by the constitutional decisions in Makwanyane and Port Elizabeth Municipality respectively. The strong link between human dignity and equality is conceptualized in the value of Ubuntu. Although not expressly mentioned in the Constitution, it was nevertheless recognized as a constitutional value in S.V. Makwanyane. Justices Madala and Mukgoro addressed Ubuntu in Makwanyane and both attributed to Ubuntu a far-reaching and fundamental role in South Africa's constitutional dispensation. The sentiments expressed have proved influential. O'Regan J. remarked as follows in Makwanyane: "The right to life is, in one sense, antecedent to all other rights in the Constitution. Without life in the sense of existence, it would not be possible to exercise rights or to be the bearer of them. But the right to life was included in the Constitution not simply to enshrine the right to existence. It is not life as mere organic matter that the Constitution cherishes, but the right to human life, the right to share in the experience of humanity. This concept of human life is at the center of our constitutional values. The Constitution seeks to establish a society where the individual value of each member of the community is recognized and treasured. The right to life is central to such a society. The right to life, thus understood, incorporates the right to dignity. So the rights to human dignity and life are entwined. The right to life is more than existence, it is a right to be treated as a human being with dignity. Without dignity, human life is substantially diminished. Without life, there cannot be dignity. Conclusion. The rights to life and dignity are the most important of all human rights, and the source of all other personal rights in Chapter 3. By committing ourselves to a society founded on the recognition of human rights, we are required to value these two rights above all others. And this must be demonstrated by the state in everything that it does, including the way it punishes criminals. This is not achieved by objectifying murderers and putting them to death to serve as an example to others in the expectation that they might possibly be deterred thereby.